Dr. Shashi Tharoor.
Thank you very much, respected Chairman. And thank you for giving me the opportunity to present my party's views on the High Court and Supreme Court Judges' Salaries and Conditions of Service Amendment Bill, which has just been introduced on the floor of the House by my good friend, Union Law Minister Shri Kiren Rijiju. Perhaps it's fitting, sir, that we're gathered here today to deliberate on this legislation just a day after the 65th death anniversary of his distinguished predecessor, a leader who was in many ways the principal architect of the constitutional foundation which has firmly guided India since independence, and that, of course, is the late Dr. Baba Sahib Bhimrao Ambedkar. Such is his eternal legacy, sir, that the greatness of this extraordinary Indian cannot be reduced to one issue. He was both a holder of many distinctions, but yet remarkably greater than the sum of each of his trailblazing achievements. A freedom fighter, a visionary jurist, a champion of social reform, our nation's first law minister, and perhaps above all, a colossus who had the vision and the intellect to anticipate the problems and challenges that newly independent India would soon have to confront. In the process, he drafted with remarkable prescience the best check and balance mechanism in the book of law, our Constitution, a bulwark that would protect the interests of our people for generations to come. Of course, Dr. Ambedkar realized that it's perfectly possible to pervert the Constitution without changing its form, merely changing the form of the administration to make it inconsistent and opposed to the spirit of the Constitution. Our Constitution, he sagely warned, is only as good as those who work it. That is where, sadly, India seems to be falling short. And I would be remiss if I did not mention that we are debating this legislation a day after the anniversary of the demolition of the Babri Masjid, an incident that remains a blot on our collective consciences and emblematic of the dangers that Dr. Ambedkar warned us about. Now, turning to the bill before us, to put it simply, the bill proposes to amend the High Court Judges' Salaries and Conditions Service Act 1954 and the Supreme Court Judges' Salaries and Conditions of Service Act 1958, and seeks to bring clarity on when Supreme Court and High Court judges are entitled to an additional quantum of pension or family pension on attaining a certain age. I appreciate the bill and the legislative clarification that this pension benefit to a retired judge shall be provided from the first day of the month in which the judge completes the age specified, and not from the first day of his entering the age specified therein. My party has no difficulty supporting this measure. However, the title of this bill refers to salaries and conditions of service of judges of the Supreme Court and High Courts. This points to other issues that could usefully have been addressed in this bill, issues of far greater importance to the democratic foundations of our nation. Mr. Chairman, the government should have considered using this bill to address and resolve critical issues of the judiciary relating to conditions of service, such as matters of the retirement age of judges, particularly High Court judges, and the implications of that for the pendency of cases in the courts. I'd like to ask the Minister whether there's any plans to increase the retirement of the judges of the High Court from 62 to 65 years to bring them on par with the retirement age of Supreme Court judges who retire at 65. There have been important recommendations from experts to this effect. The 2002 Venkatachalaya report, for instance, had recommended that the retirement age of High Court judges be increased to 65, though then added that Supreme Court justices should retire at 68, which many felt, of course, that the two ages should be the same. The UPA government sought to implement this age increase recommendation through the Constitution 114th Amendment Bill 2010, which provided for increasing the retirement age of High Court judges from 62 to 65, but unfortunately the bill could not be taken up for deliberations and it lapsed on the dissolution of the Lok Sabha in 2014. But even so, the importance of this measure was subsequently reiterated again by Justice Kurian Joseph of the Supreme Court, who recommended in 2018 increasing the retirement ages of the judges in the higher judiciary to decrease the pendency of cases. So now, despite such measures offering at least a partial solution to the alarming levels of pendency that plague our top courts, it's both surprising and worrying that the Ministry of Law and Justice has declared that there is neither a proposal as of now to increase the retirement age of Supreme Court judges from 65 to 67, nor bring those of their High Court colleagues to an equal footing from 62 to 65, and provide a uniform retirement age for judges of High Courts and Supreme Court. This illogical position blatantly contravenes the recommendations made by the Parliamentary Standing Committee on Personnel, Public Grievances and Law and Justice, which has pointed out that there is a need to revisit the age of retirement of High Court judges to compensate for the large number of vacancies existing in the High Courts. Surely, my good friend, the Honourable Minister would agree that if we are discussing conditions of service of judges, we need to urgently address the most fundamental impediment to the effective functioning of judges, the staggering vacancy rate in judicial positions across the country. This is a problem that once drove a sitting Chief Justice of India to tears in front of the Prime Minister, but even his tears appear to have left the government unmoved. As the old legal cliche goes, justice delayed is justice denied. But how can we expect justice to be delivered in a timely manner when 406 posts of judges are currently lying vacant in 25 high courts around the country, against a sanctioned strength of 1098 as of November 2021, 406 are vacant. That's 40%, sir. 41% of the total strength. And in the high courts of Delhi, Allahabad, Calcutta, Gujarat, Madhya Pradesh, Patna, Punjab, Haryana, Rajasthan, Telangana, all of them have shortages of more than 1/3 of their total judges' strength. Now, this is not just an issue that affects the citizens of the country for whom, in these conditions, the process of seeking justice has in many ways become a punishment in itself, sir. It also holds worrying ramifications for the governance of our nation. It should be a matter of grave concern for all of us in this House when we recall the warning issued by the Supreme Court, which pointed out that the government's administration will also come to a standstill if vacancies in the courts and pendency of cases are not taken into consideration for immediate and remedial action. There are a staggering 4.4 crore cases pending in the country that include over 3.77 crore cases in the subordinate courts, 57 lakh cases in the high courts, and 73,000 in the Supreme Court, as of September this year. Between 2010 and 2020, pendency across all courts has grown by 2.8% annually. These grim numbers clearly imply that even if no new cases were to be filed starting from today, the time taken by the courts to dispose of just the currently pending cases at the current disposal rate would be 1.3 years for the Supreme Court and 3 years for each of the high courts, not to mention even longer for the subordinate courts. And of course, we know the situation has been further aggravated by the pandemic, which resulted in a 20% increase in pending cases in the high courts and 13% in the subordinate courts. And we all know there's no chance that we'll see a reduction in the rate at which new cases are being added to the dockets of our courts. Respected Chairman, if one were to draw a comparison with the international front, it can be seen that the standard retirement age for judges is around 70 in countries like Denmark, Belgium, Ireland, Australia, in other top courts such as the Supreme Court of the United States, and in constitutional courts in Austria and Greece. Judges are appointed for life. The judge population ratio in India is among the lowest in the world, sir. 21.03 judges per million population today, whereas countries like the UK had 51 judges per million people, the US has 107 judges, Canada has 75. We should therefore certainly want to look at the condition of service of our judges, increase their retirement age in order to fill vacancies for longer and at the same time to reduce pendency, sir. Now, there are overwhelming reasons for this government to recognize that the establishment of a higher and uniform retirement age for judges in our superior courts would enable them to discharge their judicial duties, not just independently, sir, but also allow them to do their work without worrying that they'll have to step aside when they're in their prime. It will also fortify the rule of law and protect the fundamental right to speedy justice assured under Article 21. The vast pendency of cases at all levels can therefore be effectively tackled by increasing the number of working days available to a judge by increasing his tenure. It will be considered if the ministry would plan to address issues of increasing the retirement age of judges and reducing the huge arrears of cases, along with some other vital challenges such as lack of transparency, particularly in the appointment of judges, the long detention of under trials, and the lack of information and interaction between people and courts. Our objective should always be to strengthen the Indian legal system and bring the best judicial benefits to the citizens of the country. At the same time, in order to prevent an overt concentration of power in the hands of one supreme institution, we'd be wise to examine other practices that have been found to have merit across the world. For instance, why not establish multiple courts of appeal, as has been proposed recently by the Chief Justice of India? India can certainly benefit from the creation of 4 circuits of a court of appeal between the High Court and the Supreme Court. Not only would such an arrangement go a long way towards ensuring the distribution of power, a central goal of democracy, but also facilitate regional representation and access to justice to the higher judiciary, with 4 courts of appeal situated in the north, south, west, and east of our country. These courts would reduce the burden on the Supreme Court, which could then truly function as a constitutional court, dealing only with cases carrying constitutional implications. Now, sir, the reason that we are discussing and debating proposals to strengthen our judiciary, even beyond the routine one under consideration in this bill, is that decent conditions of service are a contribution to reinforcing the independence of the judiciary, and in doing so, to strengthening democracy itself. For instance, sir, the earlier a judge retires, the greater his need for remunerative post-retirement activity, and consequently, the greater his or her vulnerability to the blandishments of the government of the day, which might be in a position to give him such a post-retirement job. Aristotle famously said the law should govern. Democracies, Dr. Ambedkar said, should rest on the rule of law. Well, democracy focuses on who exercises power. Rule of law determines how power is exercised. In fact, so intertwined are these two concepts that the United Nations General Assembly, a forum representing all the states in the world, recognize that human rights, the rule of law, and democracy are interlinked and mutually reinforcing. Now, we all know disputes are bound to arise between citizens and governments. That's normal in any state. And this is where the judiciary plays a pivotal role, settling disputes independently in accordance with the principles of the rule of law under the Constitution. And that ensures that all individuals, regardless of background or gender or status, are equal under the law. The Supreme Court has done a great job of that, sir, since 1950. It's well regarded as a prominent judicial institution across the globe. It's rendered several path-making judgments, defining legal discourse, and settling in many ways prominent positions of law in independent India. But it's also true that its independence and transparency have come under scrutiny in recent years. As Montesquieu had famously written, there's no liberty if the judicial power isn't separated from the legislative and executive power. We are increasingly witnessing this adage play out in the scheme of things in India today, with the executive's overarching, sometimes invisible and occasionally indirect control over the judiciary, contrary to the directive principle of state policy provided under Article 50 of the Constitution to ensure separation of the judiciary from the executive in the public interest. That's why, sir, this debate is so important today. The first problem has been the government's increasing influence over judicial appointments and transfers. It's interesting, sir, that in the Constituent Assembly in 1949, a speaker from your state said, and I quote, it is of the highest importance that the judges of the Supreme Court should not be made to feel that their existence or their appointment is dependent upon political considerations or on the will of a political party. Therefore, it is essential that there should be sufficient safeguards against political influence being brought to bear on judicial appointments. Of course, if a judge owes his appointment to a political party, certainly in the course of his career as a judge, and also as an ordinary human being, he will certainly be bound to have some consideration for the political views of the authority that has appointed him. That the judges should be above all these political considerations is essential. This is Dr. Pokar Sahib from the Madras constituency in the Constituent Assembly. Now, given that basic understanding, it's unfortunate that the executive has appeared to be wielding its apparent influence over the judiciary, going back to the very first term of this government from 2014, its face-off over the National Judicial Appointments Commission in 2015, tussles between the judiciary and the executive. You will remember, sir, an eminent senior advocate withdrawing from consideration for elevation to the Supreme Court, given the implacable hostility in the executive because of his previous position as Solicitor General during UPA 2 and his role as the amicus to the Supreme Court in the Sohrabuddin Sheikh fake encounter case. A number of judges were transferred inexplicably. I have the details with me, a number of examples, but I will omit them to save time today, sir. Even when their retirements were only a few months away or when their transfers implied a demotion. At least 2 of these transfers involved judges who had earlier ruled unfavorably from the government's point of view on the Ishrat Jahan and Sohrabuddin cases. Now, sticks can be balanced with carrots. We witnessed the appointment of a former Chief Justice of India as a Rajya Sabha MP. That's only on the issue of transfers, but since we're meeting the day after the 29th anniversary of the grievous act of the demolition of a place of worship, it's only fitting to recall how that act of vandalism was in effect legitimized by the court. There has clearly been a failure on the part of the judiciary to stem the irresistible tide of militant majoritarianism. We also know the court has obligingly deferred lawsuits challenging many government actions. The government was awarded a clean chit on the Rafale jet investigation case on the basis of famous sealed covers containing evidence which the CJI exchanged between himself and the government alone. This is utter disregard for following sound legal procedure and traditions of the institution, which is also visible in the voice samples case, in which Article 142 was invoked to judicially authorize the mandatory collection of voice samples as preferred by those in power. Now, we're seeing this. The Bhima Koregaon case is another well-known one. Ever since the government has taken an overwhelming upper hand in filing draconian charges under the Unlawful Activities Prevention Act against any form of dissent, sir. And in these circumstances, sir, the point is very clear. Sir, the point of order is very clear. So let me explain. The logic is...
Quote the rule.
But let me just give an example of a case that is not pending, sir, which was another example in which the government's agenda has been obliged by the judges, and that's a national anthem case, which is now well over.
No, come to the bill, na.
Yes, sir. The point is that we are seeing that decisions have been made one after the other, which go beyond the questions of separation of powers we've talked about between the judiciary and the executive. And I was giving examples to substantiate a conclusion in the House, sir. Now, the fact is that if you were to look very carefully at other matters, if you look, for example, at the abrogation of Article 370, there is an ipso facto concern of executive influence, which has seemingly constrained the judiciary. The court was seen as the constitutional instrument to define the limits of executive control over the erstwhile state of Jammu and Kashmir and to answer a number of vital questions. Can Article 356 be used to suspend an assembly in a state and then alter the nature of the state itself? Can a state be downgraded to a union territory? These are constitutional questions, sir. But by repeatedly delaying the hearing of petitions challenging the constitutional validity of this act by the executive, the Supreme Court failed to fulfill its role as a protector of the Constitution. While the court delayed consideration, our brothers and sisters from Jammu and Kashmir suffered from civil rights restrictions, the arrest and detention of many political leaders, including a colleague from this House, sir, as well as the unprecedented blackout of all means of communications and internet, demonstrating, after all, disregard for citizens' fundamental rights. These are the protections the judiciary has a mandate, sir, to protect. We've heard the same problem with habeas corpus petitions, the key constitutional tools to empower citizens when their fundamental right to life is under threat. A majority, sir, of the large number of habeas corpus petitions were left pending for long periods of time before the Jammu and Kashmir High Court. And it's noteworthy to note that Rule 8 of the High Court Case Flow Management Rules 2010 clearly states that a habeas corpus petition should be disposed of within 15 days, sir. Despite this, it took an average, for the High Court, an average of 252.5 days to hear petitions which had to be settled in 15 days. It's a blasphemous number of days when compared to the expediency, the urgency that is required by habeas corpus petition. Many commentators have contrasted this with the urgency with which the Bombay High Court dealt with a writ of a certain editor of a television channel which claims to deliver news that the nation allegedly wants to know. Similar urgency on cases involving critics of the government, ordinary citizens of the government, would be the true sign of a court that carries out its functions independently. We've also seen lassitude by the judiciary in hearing cases challenging the Citizenship Amendment Act, despite multiple petitions. The Supreme Court, for example, has till today allowed the current dispensation to go about its business, hearing the matter only 3 times since the law was passed in 2019. It has not heard cases challenging Section 435 of UAPA, which has denied bail to dozens of defendants. I might add that the protection of civil rights has long been considered one of the key duties of the judiciary. As far back as 2013, so the Guwahati High Court ruled that the CBI was in effect an illegal body, since it was not established under any statutory authority. The SC stayed that judgment, but has conducted no hearing into the matter, with far-reaching implications for the nation. And then there are other issues, sir, not pending before the courts, but ignored by the courts, from demonetization, where a 3-judge bench of the Supreme Court promised a larger bench to consider the issue, but the larger bench was never constituted. And the question of whether demonetization was constitutionally valid might now be at best an academic exercise, but even that is not an exercise that our courageous judiciary was willing to undertake. And several issues on the direct and indirect violations of Article 300A on right to property, Article 14 on right to equality, Article 19(1)D on freedom of movement, on G on trade of business, Article 21 on right to life, remain to be answered in relation to this. And by its continued inaction, the court has not just allowed the government's sins against the citizens of India to remain unpunished, but led some critics to ask whether the Supreme Court should also be considered an accomplice to the violations of rights granted by the Constitution. Now, sir, I won't go into more examples. You've got the picture as to why I've raised these matters. The migrant tragedy when COVID struck, again, Supreme Court rejected several petitions challenging the suddenness of the move, sir. The fact is, the issue of judicial insensitivity, sir. So this is linked to the simple question of whether the conditions of service...
Point of order, 1 minute, I will see.
Now that we've heard the voice of the heckler, we can continue with the substance of my argument, sir, which is that the conditions of service have a serious bearing on the lack of separation from the executive from the judiciary, and thereby have a palpable effect, sir, on the conduct of our judiciary in delivering justice to the common citizen of India. That is my very simple argument. I was giving examples to substantiate this argument. You see, the fact is, sir, we can find more examples. I will just take another 5 minutes. So the judiciary's complicity in the government's actions have been manifested in all the examples I gave. Then the culpable involvement in the electoral bond scheme, a venture which has undermined the transparency of our electoral processes, at the very foundation of our democracy. And the fact is, again, sir, the Supreme Court has had very few hearings over the issue over the last 4 years, and it has refused to stay the implementation of the scheme, while ignoring the red flags waved even by the Election Commission of India. Now, it must be remembered, sir, that the Supreme Court's inaction, or the judiciary, if you don't want me to name the court, the judiciary's inaction almost always favors those in power, because it is their actions that are being contested and challenged in the courts, sir. When the courts fail to hear a case against the government, it is effectively deciding by default in favor of the government. That is the concern that we should all have, sir. Mr. Chairman, to truly build a new India, we will need to separate the powers and roles of the legislature, the judiciary, and the executive to ensure that the first two do not merely become rubber stamps for the third. This requires a clear separation of powers in order to ensure both efficiency and democracy. By ensuring the status and condition of service of our judges, we're giving them the opportunity to increase their productivity and to exercise true judicial independence. As Dr. Ambedkar famously pointed out, and I quote, "However good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good," quote unquote. We all know this famous line. The true success of our efforts today will only come if the government proposes a larger bill to increase the retirement age of judges, to fill vacancies, reduce pendency of cases, eliminate post-retirement appointments in government, or at least have a 3 to 5 year cooling off period before any such appointments can be made for judges, and guarantee the judiciary's independence by doing this. Until then, we must confront the kinds of problems I've outlined that plague our higher judicial system and hamper its effectiveness. I therefore support this bill while deploring its inadequacy in addressing the major challenges that our judges and our judiciary must still overcome in the interests of our citizens and our democracy. Thank you, Mr. Chairman.